Okay, we're good.
I move that the Senate resolve itself into committee of the whole. Thank you, Mr. Acting President.
Heard the motion. All those in favor say aye. Opposed, nay. Senator Boner, you're in the chair.
Committee of the whole will come to order. The first Senate file for our consideration is Senate File 34. The hearing clerk will read the file.
Senate File 34, School Finance Routine and Major Maintenance Calculations, an act relating to K-12 public school finance, sponsored by the School Finance Committee.
Wait. We have a slight mistake here, so we'll get that corrected. So. Okay. Let's try that again. The next Senate file for our consideration is Senate File 6. The reading clerk will read in the Senate file.
Senate File 6, Residential Property Removal of Unlawful Occupant, an act relating to civil procedure, sponsored by the Judiciary Committee, was referred to Committee Number 1, which turned to committee recommendation that it do pass amended. Ayes, Senators Crago, Crum, Hicks, Kolb, and Olson. Senator Olson, Chairman.
You've heard the reading of the file. What's your pleasure, Senator Olson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report that it do so with the recommendation that Senate File 6 do pass. There is a standing committee amendment to this bill. I'm going to turn over the explanation of the bill to Senator Crago, and he will go ahead and move the standing committee amendment at the appropriate.
Senator Crago.
Thank you, Mr. Chairman. So before we even get started, I'd ask that the amendment be read in because we will be going through that as we go along.
Senate File 6, Standing Committee Amendment Number 1, page 1, line 5, delete.
And I would move standing committee amendment number 1, Mr. Chairman, to Senate File 6. And I will discuss it as we go through the bill because it's spread out through the entirety of the bill draft. Mr. Chairman, I bring to you Senate File 6, Residential Property Removal of Unlawful Occupant, and ask for your favorable consideration. This is a joint judiciary bill that came out of the interim, and it came to us from some of our good senators from Natrona County and some of the professionals that work selling property for a living. Generally speaking, this bill is an attempt to address the squatting problem that has popped up across our state and that was discussed a little bit earlier by the good senator from Natrona County. When we worked this bill in the interim, I was actually quite surprised to hear the many anecdotal stories about this happening around our state. I, to be honest, was unaware of it. Thought it was a coastal problem. I don't think it is. I was obviously wrong. So we walked through the bill. If you have the bill draft in front of you, there are 3 distinct parts of the bill, and I'll walk through each of them sort of in due order. The first part of the bill creates new language within Title I and provides a process for the removal of unauthorized occupants. So page 2, if we start on page 2, the meat of the bill, that's the definitions that are applicable to the new statutory provisions. Moving on to page 3. Page 3 provides that a homeowner may request an unauthorized person to be removed from his or her property by law enforcement if certain conditions are met. And those are all safeguards, really, to make sure that if we're having someone removed by law enforcement, that there's due cause for it. And so moving to page 4 through 6, these are the conditions that must be stated on the complaint, which must be signed under oath by the landowner or their agent. So that could be, for example, a real estate management firm or something along those lines. They could sign on behalf of the owner. As we go through those, the things that have to be shown on, essentially what it will be is like an affidavit. And so the things that have to be on the affidavit, first is that the person is the owner or the owner's authorized agent for the residential dwelling. If we move down, the first part of the amendment we're going to get to on page 4 is on lines 21 and 22, and you'll see that at the top of your amendment sheet there. We deleted the provision requiring that the applicant had to show the date on which the residential dwelling was acquired by the owner. because in some instances that might be difficult on short notice for the owner to recall, oh my goodness, what day did I buy this property? Or when was it given to me? A lot of these may be gifts. You may have inherited it from your parent or your uncle or whomever. And so we decided to take that off because that can be determined at a later date, but it doesn't have to be shown right on the application and could create an instance where the person on a Friday afternoon says, hey, there's someone's living in my house, I want them removed. They go in, they get the application from law enforcement, they start filling it out and they get to that provision and they just hit a standstill because they can't provide that information. So that's the first part of the amendment, is deleting that. A lot of the rest of the amendment is just renumbering provisions. So moving on to page 5, the next item or fact that the applicant would have to prove is that there's an unauthorized person that's unlawfully entered and remaining in or residing unlawfully in the dwelling. That the unauthorized person sought to be removed is not the owner or co-owner of the residential dwelling and has not been listed on the title to the property. The next one is there's no known litigation related to the property that is pending between the owner and any person sought to be removed. And the next one is a pretty important one, which is, it says the unauthorized person is not a current or former tenant. And this was a big source of discussion during the interim in the committee, because what if we're using this to get rid of someone who actually may have a colorable right or title to be there? And so this prevents those people from being thrown out of the property pursuant to this particular law. The owner would have to use the forcible entry and detainer law that's already on the books in that particular circumstance. Moving on down, that the unauthorized person is not an immediate family member, and that the owner acknowledges that an unauthorized person removed from their property or dwelling may bring a civil cause of action against them if they use this particular section of the law wrongfully. Last one is the owner is requesting, excuse me, not the last one, the next one, the owner is requesting law enforcement to immediately remove the unauthorized person from the dwelling, copy of a driver's license or other government-issued ID showing you are who you say you are. And then the last one is that you are signing it under oath. And so there will be a form, you can hand it in, say, yep, here's all the facts, I attest to these facts, and here's who I am, and here's my right to request this. The bottom of page 6, this outlines what law enforcement's responsibility is once they receive one of these complaints. And what the bill draft says is once you get this complaint, law enforcement reviews it, ensures that the applicant is actually the owner or an authorized agent of the owner, and that they are entitled to relief under this section. They then move forward, they can then move forward. Just a little bit on what law enforcement, if you go back and look at the definition of law enforcement, it includes all local law enforcement, so your sheriff's departments or your local police departments. Under the FED statute, which we currently have, that's done by your sheriff's office. Apologize. Sorry, Senator. So under our current system, under FEDs, it's all done by your local sheriff's departments. This allows other law enforcement agencies to help in this particular circumstance. Once it's verified, law enforcement then can move forward, Mr. Chairman, and remove the unlawful occupant from the dwelling. Moving on to page 8, at the very top of page 8, it talks about a civil standby, essentially is what that is, says law enforcement, if necessary, can help the owner of the property or stand by while the locks are changed. That may not happen very often, and so, and if it does, it probably won't take very long. There's actually, the next part of the amendment, at the end of that first paragraph, so beginning on line 9, we struck the last sentence of that particular section, which allowed law enforcement to charge a reasonable fee for their services on the civil standby. We heard testimony from law enforcement that they really weren't too worried about that they already provide that service. They don't charge other people for the civil standbys typically, and just to clean it up and make sure that there wasn't any confusion, the amendment removes the last sentence and takes out the ability for them to charge a fee for the civil standby. The other part of the amendment is also on page 8. And on line 8 of page 8, the term unauthorized occupant, we changed that out for unauthorized person, and that also, the same amendment is on line 15 of page 8, and that was just conforming because we used the terminology unauthorized person throughout the rest of the bill. Moving to page 9, this is sort of the safety mechanism built into this law. On page 9, it allows a person who's removed pursuant to this law to bring a civil action against the owner or their agent if they were wrongfully removed. The hammer in this particular piece of safety mechanism is the reasonable attorney's fees, so you can recover your attorney's fees if you have to bring an action pursuant to this particular bill. I would also note on page 10 that we are not preventing people from using the forcible entry and detainer process that's already contained, and that's noted on lines 5 and 6 of page 10. Also on page 10 is where we get into the second part of the bill. And on this, in this particular section, the bill created a new crime and an associated penalty for presenting false documents purporting to be a lease, deed, or other ownership documents. It creates a misdemeanor crime. And if you turn to at the bottom of page 10 and at the top of page 11, a felony crime, Mr. Chairman, was also created for anyone listing or advertising residential real property for sale knowing that the purported seller does not have legal title or authority to sell the property. And so this was one that was requested by those folks that sell real estate in our state. Apparently this is becoming more and more of a problem. It's something a lot of their associates in other states are seeing, and so we're just trying to get ahead of that with this particular new criminal provision. And then the very last part, right now we have, and this is the third part, right now our property destruction and defacement statute is a misdemeanor and a felony, but it's based on the amount of the destruction. And so what this particular statute does is creates a new felony under property destruction and defacement, so that if you are one of these people, an unlawful occupant, and you are residing in one of these places and you happen to get caught, regardless of the amount of damage you do, it becomes a felony under this new provision. And so that's the end of the bill draft. I think that accurately describes the amendment, and so I'd ask for a vote on the amendment after questions. Thank you,
Any
Mr. Chairman.
questions on standing committee amendment number 1? Okay, seeing none, all those in favor of standing committee amendment number 1 to Senate File 6, please say aye. Aye. Opposed, say no. Amendment carries. We're back on the bill. Senator Anderson.
Mr. Chairman, I want to compliment the Judiciary Committee, the interim committee, and the present one on this bill. My constituent brought this, and all we wanted was to change it from a civil action to a criminal action, and you can see what they had to go through to make that right. I mean, I had no idea they were going to have to affect so many different statutes. So they really worked hard on this, and we got a product that we can be proud of, and we can stop squatters in the state of Wyoming. Thank you.
Any further discussion? Senator Nethercott.
Thank you, Mr. Chairman. Just a question about how I anticipate this to be utilized more than the squatter situation, which is unmarried domestic relationships. So you have two people cohabitating and they break up. And is law enforcement going to be called to remove an individual who's now unauthorized because there was a fight from an abode? So more conversation from the committee about the burden placed on law enforcement to intervene on some of these domestic circumstances, how it could be used as a tool for domestic abuse potentially. That all I have to do is fill out a form that says these things are true, give it to a police officer, and the police officer will remove me from my home. So any kind of thoughts about any additional due process or how this really applies in the real world in those situations where it's not this stranger squatter, but more likely somebody that is known to the situation.
Okay, Senator Landon, then we'll get to Senator Hutchings.
Thank you, Mr. Chairman. As usual, the good senator has hit on one of the very big button issues that we did consider during the interim. There is language in the bill that refers to immediate family, but we might want to assure ourselves that a cohabitation situation may not be covered in that circumstance. But that's exactly why the committee went there, was to try to guard against the shenanigans that can take place in family law. And you're absolutely right, that can become a real difficult set of circumstances that are tough to get your arms around. So we may want to ponder an amendment to this bill that would cover the situation that the senator just outlined. But that is why we put the family clause in the bill. I believe it's on page 5, Mr. Chairman. So thank you.
Senator Northcott, then we'll get to Senator Hutchinson.
Yeah, thank you, Mr. Chairman, I appreciate that. And the reason why I brought up that scenario is the circumstance that I presented is not family, right? They are unmarried, they are in a relationship, whether it's a friend or a romantic relationship. So oftentimes you're helping out somebody, right? And you let them stay in your place. And the terms of that are somewhat vague. And then you don't want them there anymore when the substance abuse doesn't go away, when they're not paying their way, when they're not cleaning their room. But there's no lease in place, and you invited them in, and you asked them to leave, and they don't. Then what happens? Can you call the police and have them removed? Well, you gave them permission to enter. And it's kind of a dicey situation. So whether or not it's a romantic partner or a friend or some other, you're not family, but you have invited them to stay either in your home or in some other residence of which you have access to, and you didn't get a contract in place, you didn't get a lease in place, you never thought it would end badly. Then you call the lawyers, and the lawyers say, not a lot of good options for you. You've created what's called a tenancy by the month. We have to go through this formal due process before we take away someone's home, remove them from their home without any other shelter, rather than based on just this complaint, because I am inconvenienced and tired of my poor decision of inviting this person in to live. So I just want to urge great caution about my hesitancy about what seems to be an expedient solution to what is more often than not a much more complicated situation.
Okay, Senator Hutchins.
Thank you, Mr. Chair. I applaud the presenter of the bill. He did a nice, smooth job of, but he went into some acronyms and words that I don't really understand. FED system, if you can explain that to me. And you said something about a civil standby. You went through that like we all should know, and I would appreciate a definition. Thank you, Mr. Chair.
Okay, any further questions? Back to you, Senator Grego.
Thank you, Mr. Chairman. So thank you for the questions. So FED, forcible entry and detainer. And that's essentially Wyoming's version of eviction law. And so that's in Title 1, Chapter 21, if you want to look it up. And it's in a civil standby, that's just where a citizen asks your local law enforcement maybe to, often happens in FEDs, for example, where you ask the sheriff, or usually it's the sheriff in that particular instance, to accompany you to the home while you move out the person's belongings that no longer is allowed to stay in your dwelling or in your apartment or whatever it may be. And so that's what the civil standby applies to. Thank you for the questions.
Any further discussion? Senator Scott.
Mr. Chairman, my question is on the paragraph that begins at the bottom of page 6 on line 20 and relates to the business of the law enforcement verifying the person is the record owner and resident and is entitled to relief. What happens in the circumstance where somebody filed a false deed, and the one being evicted said they were relying on that or had a lease from those people. And law enforcement is faced with a recorded deed that may be invalid, and there's a criminal offense committed doing that. But are they then able to validate by other means? How does that work?
Okay, any further questions? Okay, looks like there's none. Senator Craigo?
So thank you, Mr. Chairman. Great question, Senator. So we actually had a lot of discussion about this very point, both during the interim and just when we heard this in committee recently. And so in talking with our friends in law enforcement, that there's multiple ways they can verify this. Some of them take longer than others. And so if it's a simple, phone call to your local treasurer, local clerk, find out who's, assessor, we have lots of county officers that could answer the phone. Most of our counties nowadays, you can look it up online and see who the record owner is. But in that circumstance, you may not be able to get an immediate action by your law enforcement. If they can't verify exactly who it is, they're not going to be able to take action until they're able to dig into it. So, if this happens, it might be the next day before they're able to actually figure it out, who actually owns the property. If it happens on a Friday, it might be Monday, and there's not a whole lot we can do about that because we're making them at least verify who the owner is before they're, to make sure there are some, guardrails, some safety mechanisms built into this. But in most instances, what law enforcement told us is they're going to pick up the phone, they're going to call the county clerk or the county assessor and say, who owns this, and track it down that way. Hopefully it answers your question. If not, I'm happy to try again.
Any further discussion? Okay, seeing none, all those in favor of Senator Olson? Now, when the committee of the whole rises to report, to do so with a favorable recommendation on Senate File 6, say aye. Opposed, say no. Senate File 6 is passed committee of the whole. The next Senate file for consideration is Senate File 7. The reading clerk will read the file.
Senate File 7, Protection Order Amendments, an act relating to stalking, sexual assault, and domestic violence protection orders, sponsored by the Judiciary Committee. It was referred to Committee Number 1, which returned a committee recommendation that it do pass amended. Ayes, Senators Craigo, Crum, Hicks, Kolb, and Olson. Senator Olson, Chairman.
You've heard the reading of the Senate file. What is your pleasure, Senator Olson?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report that it do so with the recommendation that Senate File 7 do pass. There is a standing committee amendment as well to this bill. And I'm going to turn the explanation of the bill over to Senator Crum. The amendment significantly actually alters the bill, but it's probably better to explain the amendment as we walk through the bill. So I'll leave that up to Senator Crum.
Okay, thank you. Senator Crum.
Mr. Chairman, as Senator Olson, or my good senator from Cheyenne, said, I'd like to have the amendment read in if we could, please, as we walk through the bill.
Senate File 7, Standing Committee Amendment Number 1, page 1, line 3, delete.
Go ahead.
And I'd like to move the amendments. Okay, this bill, well, it seems complicated. It's very straightforward at the end. What we're doing, Mr. Chairman, is bringing Title 7 and Title 35 in alignment with each other. Title 7 is kind of the sexual assault piece. Title 35 is domestic violence. So what we're trying to do is align those two titles together and not have conflict throughout the document between the two sections. So with that, just kind of walking through the bill, the first amendment is page 1, line 3. If you look at that, what we're doing is deleting the word extending the time to a 2A. And what this is doing is just kind of cleaning up some language in the bill as we go through it. And then we've got line 1, 4, and again, hearing on a petition. So the thing will read, amending provision regarding the appointment of counsel, amended filing and service of notice. It's just kind of cleaning up that language in that part of the bill. Page two, line 22, we're taking out petition is not. And what that does, that brings us in alignment with section 35. But this part of the bill, we're talking about section 7. So that's bringing us in alignment with section 35. Page 2, line 23 with the amendment, we're dropping, we're reinserting all this stricken language there. What we had talked about was when would the victim, potential victim, get help and services offered to them? And the question was it up to age 21? Was the original recommendation on this bill. The original statute said it wasn't addressed, so everybody had a chance. We talked about age 18 versus age 21, and we came back that it should be open to everyone. If something like this happens to them, they ought to have the ability to have the services. So we took out the age 21 and put in the original language of the statute. Then on page 3, line 11, it was originally 72 hours to get action on this. The recommendation coming out of the interim was 10 days, and we thought getting 10 days to get a decision was way too long, and so we moved it back to the original 72 hours. And then page 3, line 12, we took out, just what I said, we took the 10 days out. Page 3, line 18, again, we put in the stricken language that was there. In page 5, line 3, it talked about how does somebody receive service, Mr. Chairman, and we talked about what was the best way, and we ended up deciding that the best way to give service to somebody on a protection order that was going to be extended would be through certified mail and regular mail. So they would get a regular mail. If they refused that, it would come back, but then we'd also have the certified mail that would give us some accurate documentation that would show that we did try to get them served. So that's really the bill. The rest of it is really a duplicate of what I just talked about in section 35, the removal of the 10 days back to 72 hours, the removal of the age limit, and the certified mail. So it's without going through the rest of it. And with that, I'm open for questions on the amendment.
Okay, any discussion on the standing committee amendment? Okay, seeing none, all those in favor of standing committee amendment number 1, this Senate File 7, say aye. Aye. Opposed, say no. That motion carries. Are back on the bill. Anything else, Senator Crum?
No, again, it's really, this bill's really about bringing the two sections together, section 7 and section 35, and have them run in parallel to each other.
Okay, any discussion on Senate File 7? Okay, seeing none, all those in favor of Senator Olson's motion that when the committee of the whole rise to report, do so with a favorable recommendation. Senate File 7, say aye. Those opposed, say no. Senate File 7 is passed committee of the whole. The next Senate file for our consideration is Senate File 40.
Senate File 40, zoning protest petition amendments, an act relating to cities and towns, sponsored by the Appropriations Committee. It was referred to committee number 2, beg your pardon, was first referred, yes, to committee number 2, to turn to committee recommendation that it do pass amended. Ayes, Senators Driscoll, Guru, Larson, Salazar, and Smith. Senator Salazar, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Guru?
Thank you, Mr. Chairman. I'd like to move that when the committee of the whole that rises a report, it do so with a recommendation that Senate File 40 do pass. And for an explanation of this wonderful little bill, I am going to call upon myself.
Go ahead.
Thank you, Mr. Chairman. I do have a standing committee amendment, and if I could have that read in now, that would be helpful.
Senate File 40, Standing Committee Amendment Number 1, page 2, line 3, delete.
Thank you, Mr. Chairman, and I'll work that in as we work this bill. Mr. Chairman, members of the 68th, this bill comes from your Regulatory Reduction Task Force. And as you know, as a task force, we can't author our own legislation. We have to send it through. And the co-chairman from down the hall and I, acting as co-chair, sent it through appropriations. What this bill essentially does with regulatory reduction, we worked in the energy field, we worked in agriculture, but main focus was housing. And what we're attempting to do with this piece of legislation is to uphold landowner rights as neighbors, but also give some rights to people that are developing property, where right now we feel that it has been a bit of a high bar sometimes to get a subdivision off the ground with protest positions coming from neighbors, but understanding that they do have definite rights in this. So what we're trying to do is find a sweet spot from where we stand today with statewide legislation to something that gives a little bit more flexibility. And that's where Senate File 40. It's a small 2-page bill, as you can see, an act relating cities and towns, amending zoning protest petitions. As you drop down to the bottom of page 1 is where the meat of this bill is, starting on line 12. And a protest against a change in regulations, restrictions, or district boundaries signed by the owners of, signed by owners who can demonstrate a concrete and particularized harm or either own 50% of the area of the lots included in the proposed change area. Comprise 50% or more of those owners immediately adjacent with a distance of 500 feet. And the change would be effective with the affirmative vote of a majority instead of 3/4 of all the members of the governing body. In determining the 500 feet, with an intervening street alley shall not be included. So basically, it gives opportunities for neighbors to answer legitimate questions or legitimate concerns, and have a number that have to vote in the affirmative to do so. But the bar is not quite as high as it used to be. So we're trying to get to that sweet spot. Now, with regards to the amendment, the Appropriations Committee, when they took up this bill yesterday, felt that the 500-foot rule was a little bit too much for them. And so what they did was they cut it both on page 2, line 3, and page 2, line 7 to 300 feet. So that change, so it started at 150 or 140 feet. The task force took it to 500. The committee dropped it back to 3. So they felt that the committee felt, appropriations felt that was closer to that sweet spot that we were looking for. We know as business people, I'm a businessman, a lot of you are business people, especially when it comes to development, time is money. And so that's what this bill is about trying to get good projects off the ground in an expeditious manner, but still giving rights to landowners who are affected. That's the essence of the bill. Glad to stand for any questions.
Okay, would you please move that amendment, please?
Oh, I'm sorry, I got to move the amendment too. I would move standing committee amendment number 1 to Senate File 40 and ask for your favorable consideration.
Okay, so let's discuss the amendment first. Anybody on the standing committee amendment? Senator Ide.
Thank you, Mr. Chairman. I'm not sure if I'm going to address the amendment or the bill. Does it matter if I speak now, or I'm not sure if it falls into I'll just wait until we go to the bill.
Okay, sounds good. So we have an amendment that would change the distance from 500 to 300 feet. Any discussion on that? Okay, seeing none, all those in favor of Senator DeRue's motion to adopt standing amendment number 1 to Senate File 40, say aye. Aye. Opposed, say no. No. That motion carries. Back on the bill. Senator Ide.
Thank you, Mr. Chairman. I noticed this bill, I think I like the bill, actually. But but it just says cities and towns. Did you guys talk about counties? And would that fall into any of the trouble with development stuff if there was a development going on and it was in the county and it was zoned in the county? It's just some question there. Thank you, Mr. Chairman.
Senator Grew?
Any others? Okay. Mr. Chairman, we did discuss it, and well, let me get back to you on the exact reason, but we did have that discussion, and we fell back for now to cities and towns. But it may have been a miss, but I'll check and get you an answer. Further point, as a former member of the task force, we talked a lot about the issues, frankly, that you talked about, and this was one of the bills that came from that, as far as trying to figure out ways that we can actually expedite and save time. Because in a big construction project, time is critical and lethal in some cases. Thank you.
Any further discussion on Senate File 40? Senator Pappas.
Thank you, Mr. Chairman. My question is who is going to adjudicate the harm that's being done? Who's going to make that decision? Is that just up to the regulatory body, or it seems a little bit vague to me?
Okay, any further questions? Senator Drew.
Thank you, Mr. Chairman. We got that from an outfit that came and testified, a legal outfit that came and testified and has been working these bills all over the country and in trying to figure out ways. And this was language that was offered up from them as a standard for the regulatory body to be able to judge and then have an avenue then to go to court to adjudicate if they wanted to adjudicate further. But I was trying to split, once again, that sweet spot to try to give someone who's a little farther away a bit of a hammer if there's some specific thing, usually a topographic thing, something about water, so, and making sure that, or felt this could be a specific harm to a specific landowner.
Okay. Any further discussion? Senator Kolb.
Yeah, thank you, Mr. Chairman. Just a question. I thought the Regulation Reduction Task Force was supposed to make things, I guess, less regulations, things run smoother. It would seem like somebody could use this change to, in fact, put an impediment on any development by protesting a change that they don't like during a, let's just say you were doing something that was, I don't know, less restrictive, and the people like something that was more restrictive. So they protest said change. And is there some protections against making it more difficult to make changes? Or is this what this is supposed to be? That's my question. Thank you, Mr. Chairman.
Any further discussion? Senator Crago.
Thank you, Mr. Chairman. Question for the bringer of the bill. As I read this and I read through it, so you file a protest, you have to have meet a certain threshold to file a protest. And then once the protest happens, it just takes a simple majority of the governing board to continue on with the zoning decision anyways. So what exactly does the protest do other than alert that there might be an issue? I mean, the protest can't really, under current law, the protest can actually hold up the decision-making process, right? So I can say, as a landowner adjoining this particular project, I can say, I don't like that. And if I can get 3/4 of my brothers and sisters to agree, I can stop it because whatever the threshold is now, but it takes 3/4 of the governing body to override that protest. So what exactly does the protest do in this particular proposed legislation?
Any further discussion? Okay, Senator Drew.
Thank you, Mr. Chairman. Right now, we feel this is a regulatory reduction deal in answer to your question in specific, because right now, one landowner with enough land next to a project can shut the project down and never have to say another word except, I don't want it. And that's a pretty tough bar. And then to add 2/3 of the governing body have to say no to that question is yet a higher bar. Lowering that to 50% and just so a simple majority of the city council arguing that, but you have to come with a specific complaint and a specific reason that this is harming your property. That is actually easier for the governing body to kind of hone in on. What is it? Is it really a detriment, or isn't it? And then if it's not, they can take it farther if they feel they need to. But this way, it kind of takes, we felt what we were looking for is to take out the more frivolous nature that is involved with this, with these higher thresholds, which just are, and it's been happened in this community, it's happened in the communities around the state where good projects have just gone away because it's just too hard to reach the threshold. And one, either a small group of neighbors or in some cases, one neighbor can shut you down.
Any further discussion? Senator Rothfuss.
Thanks, Mr. Chairman, and I appreciate that discussion. I better understand it at this point, how it would play out. But, you've got the circumstance where the limiting case of one individual stopping things, and I can see where that plays out based on the original language. But I was curious about any conversation where the pendulum maybe is swinging too far the other way, where you can imagine a situation. We have a lot of circumstances where we have perhaps out-of-state landowners, people that are absent when it comes to engaging in the particular property. And as we expand the requirement to have a nexus of concern in place, it might get to the point where the opposite happens, where there's literally no way you could get phone calls back or participation by a full 50% of either the owners or the property ownership. And I was wondering if there was discussion about that. It seems like this is one of our good colleagues who used to debate from over there said if it's worth reacting to, it's worth overreacting to. And have we swung the pendulum a little bit too far on this one, where it's a bit of a challenge to protect a legitimate concern instead of protecting against an illegitimate concern?
Senator Steinmetz.
Thank you, Mr. Chairman. This is just a question on the process as a whole. A few years ago, we had a lot of pushback when I was on appropriations about bringing a litany of bills through the Appropriations Committee. So I just wanted to know why this is in the Appropriations Committee, especially when we don't have a supplemental budget yet, and so why we're running these bills first, and just a process issue as to what we're doing here. Thank you.
Okay, Senator Case.
Thank you very much, Mr. Chairman. On that point, frequently we've been down here and we have not gotten a supplemental budget or a regular budget passed till the last day that we are here. It isn't often the case. Each house will, we're going to do a mirror budget on the supplemental, I assume. Each house will work that, and we might know what our house thinks, but we don't know what the legislature is going to come up with in the end. That is an impossible standard to say that we can't begin our work here until after we've passed the budget. It is just impossible. The budget very well could not be passed to the last day we are here. Maybe, I hope that's not the case, but it would be an impossible standard to say that we can't pass any of it. This is not the Ways and Means. We don't have that ability here. So, and also note that in the supplemental budget will be minuscule compared to the overall responsibilities of the state of Wyoming and the jobs that we have that extend for years. Thank you, Mr. Chairman.
Okay, any further discussion? Senator Grew.
Thanks. Thank you, Mr. Chairman. Real quick, I just wanted to answer my good friend from across the hill. It was discussed. It was discussed. And it was the feeling of the Regulatory Reduction Task Force and everyone who testified in front of us that housing right now, whether it's affordable housing in my neck of the woods or just quality housing in a lot of other communities around the state, is an impediment to business growth and a clear and present danger to our economy. We felt that this cut of close enough line to be able to address it in that way, and also make sure that we try to leave the protections that private property owners, neighbors want, but also protect the private property rights of the people that are doing the developing. That's the second point. This came through appropriations because, in one simple reason, it was the last meeting that we finished this bill and finished working on this bill. It's the only committee left that still had meeting dates in December. Also, the co-chairman and myself from the other side are both members. He was at that point the chairman of appropriations on down the hall, and I was a member on this side. So that was where it came from. There's about 3 or 4 of these, and we wanted to get them kicked out as quick as possible. Thank you, Mr.
Okay, any further discussion on this bill? Seeing none, all those in favor of Senator Garew's motion that when the committee of the whole rise to report, do so with the favorable recommendation of Senate File 40, say aye. Aye. Opposed, say no. Senate File 40 has passed committee of the whole. Madam Majority Floor Leader.
Mr. Chairman, thank you. I move that the committee of the whole rise and report.
You've heard the motion. All those in favor say aye. Aye. Opposed, say no. Motion carries.
Thank you, Senator. Can the reading clerk read the committee of the whole report?
Mr. Vice President, your committee of the whole, having had under considerations bills on general file, begs leave to report as follows. Senate File 25, do pass. Senate File 11, do pass. Senate File 6, do pass amended. Senate File 7, do pass amended. Senate File 40, do pass amended. Senators Driscoll and Boner, Chairman.
Senator Boner.
Mr. Vice President, I move adoption of the committee of the whole report.
You've heard the motion. All those in favor say aye. Those opposed, carried. Madam Majority Leader.
Mr. President, I move that we stand adjourned until 10 a.m. Monday.
Madam Majority Leader, just one moment, please.
Sure. What date is Monday?
Can we hold for just a minute? I guess we have some standing committee reports.
We do have standing committee reports. Thank you, Madam Chief Clerk.
Mr. Vice President, the following reports are dated January 17, 2025. Committee number 4, Education, to whom is referred Senate File 34, School Finance Routine and Major Maintenance Calculations. Respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators Brennan, Olson, Rothfuss, Schuler, and Scott. Senator Schuler, Chairman. Mr. President, your committee number 4, Education, to whom is referred Senate File 72, Summer Vacation Preservation Act, respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators Brennan, Olson, Rothfuss, Schuler. No, Senator Scott. Senator Schuler, Chairman. Mr. Vice President, your committee number 4, Education, to whom is referred Senate File 44, Fairness in Sports, Intercollegiate Athletics, respectfully report same back to the Senate with a recommendation that it do pass amended. Ayes, Senators Brennan, Olson, Schuler, and Scott. No, Senator Rothfuss. Senator Schuler, Chairman. Mr. Vice President, your committee number 9, Minerals, Business, and Economic Development, to whom was referred Senate File 18, Enhanced Oil Recovery Severance Tax Exemption, respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators Anderson, Cooper, Jones, and Nethercott. No, Senator Rothfuss. Senator Anderson, Chairman. Mr. Vice President, your committee number 3, Revenue, to whom is referred Senate File 48, Business Property Exemption, respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators French, Ide, McEwen, and Pappas. No, Senator Case. Senator McEwen, Chairman.
Senator Schuler.
Thank you, Mr. Vice President. I would like to request that Senate File 34, School Finance Routine and Major Maintenance Calculations, be re-referred to Appropriations. Thank you.
Senator Anderson, do you have a A re-referral?
Yes, Mr. Vice President, I'd like to re-refer Senate File 17 and Senate File 18.
Point of order first.
Yes, Senator Office.
Thank you, Mr. Vice President. My apologies for interrupting. You'll have to announce that the prior one was re-referred, take action on that prior to moving to this one. So absent that announcement, we shouldn't move on to the next re-referral.
Okay. So Senate File 34 has been referred to Committee Number 2.
Without objection.
Appropriations without objection.
Yep.
Thank you.
Okay.
It's only 18.
Okay.
Thank you.
Now Senator Anderson.
Now we can do it?
Now you can do it.
I've been corrected, 17 isn't out yet. I would ask that Senate File 18, Enhanced Oil Recovery Severance Tax Exemption, be re-referred to appropriations. Thank you.
Without objection.
was wrong.
18 will be referred to appropriations. Number 2.
What happened to 17?
You should see 17 over 2 because it's 1-1.
Senator Cole,
Privilege of the floor.
please.
Thank you, Mr. Vice President. Just like to report to the body that I will be traveling for the presidential inauguration on Monday, and I'll be on Tuesday, and hopefully back early Wednesday to our next President Donald J. Trump. Thank you, Mr. President. Vice President.
Thank you, Senator. Now, Senate Majority Leader.
Thank you, Mr. Vice President. Just for everyone, and in light of our caucus yesterday, that would be a privilege of the floor, an announcement to speak about something someone personally wants to share. But where we are is, Mr. President, I move that we stand adjourned until 10 a.m. Monday, January 20th, 2025. Now there'll be time for announcements to all the new committee chairmen that are waiting to give their announcements. Thank you.
Announcements. Mr. Minority Leader.
Thank you, Mr. Vice President. Your committee number 2, Appropriations, is going to have 2 meetings that we'd like to tell you about. First one is Monday, January 20th at 8 a.m., where we will meet to discuss, wait for it, the supplemental budget. Then at Monday at noon, recess on January 20th, your committee number 2, Appropriations will take up the following bills. Senate File 14, Wyoming Imagination Library Program. Senate File 41, Federal Acts, Legal Actions Authorized. Senate File 81, Tax Exemption Property Owed by the State. Senate File 99, Game and Fish Property Tax Exemption. And Senate File 34, School Finance Routine and Major Maintenance Calculations. That meeting will be at noon, and that meeting will be in W113. The 8 a.m. meeting will be in our usual JAC room E301.
Thank you, Mr. Minority Leader. Chairman Landon.
Thank you, Mr. Vice President. Just a heads up for next Tuesday, I announced earlier that we will take up the bonus point bill. A lot of interest in that bill, game and fish related. We're going to try to have a special meeting at noon on that day, an additional meeting for the Travel, Recreation, and Wildlife Committee. We don't have a room at this point, but we're going to take up the deer bill, mule deer and white-tailed deer, and decide if we want to split those species and have a robust discussion at noon that day. So 2 meetings for the TRW committee. Wanted to have you get prepared over the weekend for that. Thank you.
Thank you, Mr. Chairman. Chairman Schuler.
Thank you, Mr. Vice President. Just again, another mention about our Education Committee. Number 4 will be meeting Monday, 8 a.m. in room W10, 110. We'll be looking at Senate File 90, Youth Organizations in Schools, Senate File 21, Ban on Cell Phone Use in Schools, Senate File 73, Charter School Funding Amendments. Thank you.
Thank you. Any other? Chairman Pappas.
Thank you, Mr. Vice President. Your Transportation, Highways, and Military Affairs Committee will be meeting Tuesday, 8 a.m., to take up the following military bills. In this order: Senate File 26, Protection of Military Equipment; Senate File 27, Wyoming National Guard Member Referral Amendments; Senate File 29, Firearm Hold Agreement limited liability. Senate File 31, boards and commissions, veterans ex officio members. And if we have time, Senate File 28, ROTC endowment program. Thank you, Mr. Vice President.
Madam Majority Leader.
Thank you, Mr. Vice President. The Rules Committee will have a joint meeting of the Senate and House Rules upon adjournment in State Capitol Room East 202 and online. Again, the joint Rules Committee will be meeting this afternoon upon adjournment. Thank you.
Thank you. Honorable members, I just want to mention it is going to be my intent to give you an idea of where the Appropriations Committee is. I see right now that we could be between 3 and 4 days to have that supplemental finished. So it'll be my intent, and I hope the intent of across the hall, that we could possibly have that finished by the end of next week. So I wanted to just give you a general idea of where we're at. I'm doing everything in my power to get this done, but not rush it to the point where we don't have something that's quality work. So I want you to be aware of that. Also, just a reminder, Monday, the lunch fee for all of us is due. So don't forget that. With that, you've heard the motion. All those in favor say aye. Those opposed? Then we stand adjourned until 10 a.m. Monday, January 20th.